remain silent. Anything said and can will be used against you in the court of law. You have the right to talk to a lawyer and have the present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questionings if you wish. All right. You good, dude?
Good morning. Good morning. Today is 12/29 of 2024, and I am here to hang out and talk about a few things that I haven't been able to come on live and talk about in a while. So welcome back. Today I want to dive into a case that's got everything. It's got a tragic love story, suspicious Moscow mules, children's books that have way too much things in them that they shouldn't. Yes, talking about Kouri Richins. She's a real estate agent that turned author who's now at the center of a jaw-dropping murder case. So buckle up because the story has more twists than a Lifetime movie marathon. I think what we have to do is start at the beginning. And the very first thing that I'm going to say is I have not looked through this case. I don't have a lot of detail. So I will be deep diving into this and all of the things that go along with it with you. Let's go to the very first thing that I found, which is a warrant for her. It says it's almost 100%. Okay, I'm sure that a lot of you over the years have read through all of these documents and these things. So, yeah, let's just deep dive and have some fun. See what we can figure out together. So it looks like it's Summit County. That's in Park City, Utah. Okay. And the 3rd District Court in and for Summit County in the state of Utah. This looks like the warrant of the state of Utah versus Kouri Richins, date of birth April 20th of 1990. She's a youngin'. Okay, the undersigned prosecutor states on information behalf that the defendant, either directly or as a party, committed the crime of criminal homicide in violation of Utah Code, a first-degree felony, as follows to wit. That on or about March 3rd, 2022, in Summit County, state of Utah, the defendant did intentionally or knowingly cause the death of another individual under any of the following circumstances. The actor committed homicide by means of the administration of a poison or of any lethal substance or of any substance administered in a lethal amount, dosage, or quantity. Furthermore, the defendant was a cohabitant with the victim. Dun, dun, dun. Oh, possession of a controlled substance with intent to distribute. Well, in violation of Utah Code, a secondary felony as follows, to wit, that on or about January 2022 in Summit County, state of Utah, the defendant did knowingly and intentionally possess with intent to distribute a controlled or counterfeit substance that was classified in Schedule 1 or 2, the Controlled Substance Analog, or, yes, GHB acid as listed in Schedule 3. Wow. She's a piece of work, isn't she? This possession of a controlled substance with intent to distribute in violation of Utah Code, a second-degree felony as follows to wit. That on or about February 11th, 2022 in Summit County, state of Utah, the defendant did knowingly and intentionally possess with intent to distribute a controlled or counterfeit substance that was classified in Schedule 1 or 2, a controlled substance analog, or GHB acid as listed in Schedule 3. Or possession of a controlled substance with intent to distribute, February 26, 2022, same deal. And the information is supported by the state of probable cause as follows. I was going to say, how do they know all this? On March, this is really new to me, so this is exciting. At the same time, to some of you, it's probably not, since this case has been out a while. So I want to see lots of comments telling me about this girl and about this case. And I want to go over this for the next couple of days because this sounds interesting. On March 4th, 2022, at 3:22 hours, Summit County Sheriff's deputies and EMS staff responded to a residence located at 282 Willow Court in Summit County. Okay. That gave me an address. Let's look that up. 82 Summit Court. 282 Summit Court. Surely somebody else lives there by now. Interesting. Okay, let me see if I can pull that up. Let me share it too. Let me show you. Oh, there we go. Okay, share. Oh, so maybe because so many people have looked around, maybe they've blocked out the house in that regards. That makes sense. I guess if it's not for sale, there's that. I'm sure that we're going to be able to find this. It's off the market, so it's obviously somebody else's home. 1,133,000. Let's see, estimated. Oh, yeah, they had it blurred out. They don't want us being rude. Okay, understood. I'm sure that we'll be able to find that home in another, because this is throughout the years. All right, let's go back to this warrant here. Beep, beep. Okay. At the address. Okay. On March 4th, 2022 at 3:22 hours. Summit County Sheriff deputies and EMS staff responded to a residence located at 282 Willow Court in Summit County on the report of an unresponsive male. When they arrived, they found Kouri Richins on the floor at the foot of his bed. Life-saving measures were attempted, but Kouri was declared deceased. During interviews with the deceased wife, the defendant, Kouri Richins, stated that around 2100 hours on March 3rd, 2022, she and Kouri were celebrating the defendant's closing on a house for her business. Defendant stated that she made Kouri a Moscow mule in the kitchen and brought it to their bedroom where Kouri consumed it while sitting in bed. The only people in the house were defendant Kouri and their children. Defendant stated she went to bed and shortly after went to sleep with one of the children in the children's bedroom because that the children was having a night terror. Defendant said she awoke around 0300 hours and came back to her in Kouri's bedroom. She felt Kouri and he was cold to the touch. This is when defendant called 911. Who else did we recently talk about that put their kids to bed or put their husband in another room while they slept with the kids? I remember who that was. Defendant told law enforcement that when she left her room to go to her child's room, she left her phone plugged in next to her bed and did not take it to her child's room. However, between when the defendant said she went to child's room and when she called 911, the status on her phone shows that it was locked and unlocked multiple times, and there was also movement recorded on the phone. In addition, tolls on defendant's phone show that messages were sent and received during that time. These messages were deleted. Jeez. Following an autopsy and pursuant to toxicology findings from the autopsy, it was determined that Kouri died from an overdose of fentanyl. Oh my goodness. Well, obviously we know I saw that it said GHB. The medical examiner indicated the level of fentanyl in Kouri's system was approximately 5 times the lethal dose. The OME stated the fentanyl in Kouri's system was illicit fentanyl and not medical grade fentanyl. It is also the opinion of the OME, after evaluating Kouri's gastric fluid contents, that the fentanyl in Kouri's body was ingested orally. I wonder how his drink tasted. Was it After receiving the information regarding the toxicology, a search warrant was obtained for Eric and the defendant's residence. During the service of that search warrant, defendant's phone and several computers were seized as evidence. Warrants were obtained for all the electronic devices, and the information from those devices was downloaded. When investigators downloaded defendant's phone, several communications between defendant and CL were located. You guys, somebody's got to tell me, who is CL? Who is CL? Look at this name over and over and over. This name, CL. CL was identified as an acquaintance of defendant. Sure. A police records check of CL revealed multiple counts of possession of a controlled substance with intent to distribute. This possession of a controlled substance and possession of drug paraphernalia. On May 2nd, 2023, Summit County detectives interviewed CL, and CL told detectives that sometime between December 2021 and February 2022, the defendant contacted CL via text message and asked if CL could get defendant some prescription pain medication for an investor who had a back injury. Within a few days, CL procured hydrocodone pills from a dealer, and defendant told CL to leave the pills at a house defendant was flipping in Midway. CL left the pills at the house, and defendant left cash for CL. It has been determined that this house was owned by defendant in December 2021 and January 2022. Wow. About 2 weeks later, defendant contacted CL again and said that her investor wanted something stronger and asked for some of the Michael Jackson stuff. Wow. I must be living under a rock. I know nothing of this case. The defendant asked specifically for fentanyl. CL contacted a dealer in Ogden on February 11, 2022, and procured 15 to 30 fentanyl pills from that dealer. Defendant came to CL's home in Heber, and CL delivered the pills to the defendant. CL received $900 for those pills. My gosh. 3 days later, on February 14th, 2022, Eric and defendant had a Valentine's Day dinner at their Kama's home. Shortly after the dinner, Eric became very ill. Eric believed that he had been poisoned. Eric told a friend that he thought his wife was trying to poison him. About 2 weeks later, the defendant contacted CL again, asking for another $900 of fentanyl pills. CL contacted the Ogden dealer again on February 26, 2022, and procured the pills. The defendant told CL to leave the pills at the outdoor fire pit of the Midway house, where there was cash waiting for her. 6 days later, so CL is a woman. Aha! Midway house, where the cash was waiting for her. 6 days later, on March 4th, 2022, Eric was found dead of a fentanyl overdose. That's where it all started, huh? The information is based on evidence obtained from the following witnesses. The state reserves the right to supplement its witnesses list as additional discovery warrants, of course. Defendant's last known address. That's insane. That is insane. The lady is insane. Oh gosh, how scary. Okay, let's go on to the next document I can find. Let's go down to the next document I can find. 1 second. Pull this up here. Memo in support to allow defendant to appear without restraints for court. Okay, is that the next document down? Okay, go with it. Okay. Usually make this bigger for you guys so that we can all look at it together. All right. right. Move my mic around a little bit here. Memorandum support of motion to allow defendant to appear without restraints and in civilian clothing throughout trial. So this was... Is there a date on here? I don't see a date. Maybe it'll tell further down. Okay, so this will be her case number. We didn't look at it on the last one. So 231-500-139 is going to be her case. And I don't know how to pronounce her judge name, so I will look as we go through videos. Richard Mrazek, maybe? Mrazek? Judge Mrazek? Defendant Kouri Richins, by and through counsel of record, moves this court for an order permitting Ms. Richins to appear at all in-court proceedings, including all pretrial hearings, at which Ms. Richins appears in court in civilian clothes instead of a prison uniform and without restraints by any means, including shackles or stun cuffs, belt. In addition, once trial begins, Ms. Richins requests that measures be taken to ensure that the jurors never see her in restraints in or out of the courtroom. Should Ms. Richins be found guilty during the guilt phase of her trial, she respectfully requests that these measures be extended to the penalty phase of her trial. The 14th Amendment in Article 1, Section 7 of the Utah Constitution guarantee Ms. Richins the right to be presumed innocent and the right to a fair trial. Permitting her to appear unrestrained and in civilian clothing protects these fundamental rights. If the court is not inclined to grant the instant motion on the record as it now stands, Ms. Richins requests an evidentiary hearing to adduce evidence on the question whether there is a particularized justification for restraining her or for requiring her to appear in prison clothes. And then it cites the argument for why she should be able to do that. The presumption of innocence forbids the state from compelling criminal defendants from appearing before the jury in prison clothing. The Constitution affords her the right to appear before the jury in civilian clothing. Ms. Richins has already been forced to appear in prison clothing at a pretrial proceeding covered by either television or print media, and continued media coverage of Ms. Richins in prison clothing will lead jurors to doubt the presumption of innocence, resulting in Ms. Richins' constitutional rights to a fair trial to be undermined. Okay. Due to the nature of the charges in this case and the publicity the case has generated, except for people who live under a rock like myself, apparently, media coverage of the accused dressed in prison garb creates a great potential for harm, and the harm is no less serious merely because the jury has yet to be impaneled. Requiring Ms. Richins to wear prison garb at further pretrial proceedings furthers no compelling state interest, but it would violate Ms. Richins' right as recognized in Estelle. The state is prohibited from physically restraining a criminal defendant without a specific state interest. Well, don't let her put anything in anybody's drink, apparently. Ms. Richins contends that there are no facts specific to this case that would justify restraining her in any manner during pretrial or trial proceedings, including by means of a stun vest or cuffs, hand restraints, leg restraints, or other similar tools of confinement. Okay. Due process does not permit the use of visible restraints if the court order has not taken account of the circumstances of the particular case. These are citing cases that have used the ruling in the past and why, obviously. Ms. Richins' right to effective assistance of counsel affords her the right to appear at her trial unrestrained. We get it. Lord. This court should also consider the substantial prejudice if Ms. Richins is required to appear in restraints during the pretrial proceedings. The harm is no less serious merely because the jury has yet to be impaneled. We've heard this before. Moreover, the prospective jurors will likely infer that Ms. Richins is restrained because she is dangerous. Is she not? Is she not dangerous? It should be noted that this case was investigated for over a year, during which time Ms. Richins was out of custody, providing clear evidence that Ms. Richins does not constitute a danger. Well, she wasn't trying to get everybody else and the jurors out of the way. She was trying to get her husband out of the way, apparently. For the foregoing reasons, Ms. Richins respectfully asked that the court allow her to attend all of her in-court proceedings unhampered by any restraint. The death penalty's unique nature heightens a capital defendant's right to be presumed innocent. Ms. Richins' right to a fair trial includes a right to be free from impairments of the presumption of her innocence. being forced to wear prison clothing, and being shackled while in the presence of a jury are impairments of the presumption of her innocence. Ms. Richins contends that the death penalty's unique nature heightens her right to be free from these impairments. As the United States Supreme Court, goodness, it scared me. Excuse me. As the United States Supreme Court's, what's this word? Jurisprudence has made evident, death is different. For that reason, more process is due, not less. Okay. The penalty of death is qualitatively different from a sentence of imprisonment. Miss Richins is potentially facing death as a penalty for the crime she allegedly committed. Her potential punishment, death, is unique. Miss Richins should be afforded greater due process protections than similarly situated non-capital defendants. This court should therefore allow Miss Richins to appear in ordinary civilian clothes and without restraints at all in-court proceedings and any other time the media or jurors might view her. There's the date. This was the first date of June 2023. And this must be attorney for defendant Sky E. Lazaro. Now, I don't know if that's changed now, but that was who it was at the time, apparently. Okay, well, there we go. She wants to be seen in regular clothes. Let her be seen in regular clothes. What's next? What do we have next here? Okay, we don't need a second. We've already gotten the motion to support her wearing her own clothes or some clothes of some sort. Okay, document 1 PDF. What are these documents? Oh, the estate of Eric. Let's pull these up. I'll go down these one by one and see what we can come up with. Bear with me. Switch a lot of windows for documents all at one time. Here we are. Let's see if I can't make this bigger. Just hide over here in the corner. What do we think? Should I be? No. Should I be down here? And it cover up the screen? Maybe that'll help since there's a background and it's moving consistently. Okay. Let's see here. Looks like the 3rd District, Silver Summit, Summit County, State of Utah, in the matter of the estate of Eric Richins. Parties, there's a petitioner, Kouri Richins Benson. Is that a family member, I'm assuming? Descendant Eric Richins, heir Kouri Richins. Trustee, the Eric Richins Living Trust. Account summary. Total revenue amount due. Okay. On 3/14/2022, they filed a petition for the formal probate of the will and formal appointment of personal representative. They filed the will, they filed the petition. Okay, there was a judge assigned. Return of electronic notification, acceptance of appointment. Okay, let's keep on going down here. On 3/18/2022, notice is hereby given that on March 14th, 2022, Kouri Richins Benson filed a petition for formal probate of will and formal appointment of personal representative. A copy of the petition is on file with the clerk of the court and may be reviewed upon request. The petition for formal appointment is scheduled on April 13th, 2022, before the judge. We had a virtual hearing. Okay, file returned, acceptance of service. Okay. Cases before the court for a petition for personal representative, counsel and party appearing remotely via WebEx. Okay. Counsel for the petitioner, Crystal Bowman Carter, informs the court that there is no objection to the appointment of personal representative. Court has reviewed the petition and proposed order. Court grants appointment of Kouri Richins Benson as personal representative. Acceptance of appointment has been signed by the petitioner. Court signs the order in open court. So it looks like the disposition was granted. Okay. So Kouri Richins Benson. It's got to be a direct family member. Let's look it up, you guys. I'll do my due diligence here. Katie. Eric Richins consulted both a divorce lawyer and an estate planning lawyer, unbeknownst to his wife. Oh, he changed his will, forming a living trust and placed his estate under the control of his sister, Katie Richins Benson, according to the amended court document, which is what we're looking at now. Okay. Okay. Well, he obviously knew something was going wonky, didn't he? Okay, so that's what that is. So it's just a few. This are the legalities of that. So, okay. This hearing will not take place at the courthouse. It will be conducted remotely. Contact the court to provide your current email address. 6/1 of 2023. So they were still doing stuff. Other parties, attorneys for the heir petition. Interesting. There are parties appearing in person and via WebEx for today's hearing. This matter is before the court on a motion for a gag order that has been filed. After hearing from all parties, the court rules on the record. The court will issue a protective order. Electronic notification. Okay. All right. So that was for the estate. Okay. Let's see what's next. Looks like. Let's pull this up. Just go down the documents one by one until we satisfy with what we're learning. At least what I'm learning. You guys probably already know all of this stuff, and I'm like light years behind. Okay, let's see. Ooh, it's a little too big. Go back just a little bit. Okay. Third District Court, Silver Summit, State of Utah versus Kouri Richins. Case number 231500139, state felony charges. This case involves domestic violence. Charge 1, aggravated murder, first-degree felony. These are the charges. Attributes, domestic violence, mandatory appearance. Charge 2. So we've already read through. We already knew what these were. We've already gone through the charges. And then a couple of possessions with intent to distribute the substance. Okay. Okay. The amount of money that costs to file those or get those copies. Sometimes in a case like this, you do have a lot of just documents that people pull up or things that get FOIA that just are kind of random things. That just things that are happening in the case. Just legal stuff. You are commanded to arrest and deliver the defendant to the Summit County Jail. A juvenile may not be confined in an adult facility. Thank you for the reminder. Defendant may be transported within the state. The defendant must appear in court before Judge Richard Mrazek on the next available court date. Based on the probable cause statement, court orders a non-bailable warrant to issue. No pretrial service release. This warrant may be served at any time, day or night. Law enforcement agency, Summit County Sheriff. End of order. Okay, girl. That was 5/8 of 2023. That's when the warrant came out. And then we read the warrant first. Okay. And that's all of the warrants for all of the charges. So the different warrants that were issued on that day for those charges. Okay. Okay, and then let's get down here. Let's see. Initial appearance. A copy of the information is given to the defendant. Defendant waives reading of information. Advised of charges and penalties. The defendant is advised that this offense may be used as an enhancement to the penalties for a subsequent offense. So they were recording it. Obviously. The defendant is in the custody of the Summit County Jail. The defendant was booked. Oh, I skipped all of this here. So the warrant was issued for the reasons. They had a probable cause statement. changed from sealed to private. Detention hearing scheduled for May 19th of 2023. Warrant recalled on May the 8th. Recall reason defendant was booked already. Okay. The hearing, state and defendant appeared in person. Defense counsel is appearing via WebEx. Counsel for the defendant, Ms. Lazaro, addresses the court and would like to speak with her client on a virtual breakout room. 3:43, the defendant and counsel return from the breakout room. Counsel for the state, Ms. Cassell, motions to have this matter unsealed. 3:44, the court grants the state's motion and this matter is now public. Counsel for the defendant, Ms. Lazaro, addresses the court and requests a detention hearing. The court orders that the defendant continue to be held without bail and will set a detention hearing for May 19th at 3:00 p.m. in person. And the court orders that any relevant triple I criminal history in the possession of the state shall be released to defendant's counsel. The detention hearing was scheduled for 5/19 of 2023. The defendant is remanded to the custody of the Summit County Jail. Request for discovery. Defendant's request for discovery. They want to know what they had on her. Okay. So then there's some subpoenas for certain people. They got this stuff together quick, didn't they? They knew what they had, I'm guessing. All parties appearing via WebEx. Counsel for the defendant, Ms. Lazaro, indicates that she's fine going forward without her client this afternoon. That was the 5/16/2023 hearing. Counsel for the defendant indicates, okay. Counsel for the state, Ms. Cassell, addresses the court regarding the motion to seal. Counsel for the defendant, Ms. Lazaro, addresses the court. The court addresses the parties regarding the motion to seal. Order denying motion to seal, subpoena, return of electronic notification, return of the motion on 5/18. Order granting motion to continue detention hearing. Detention hearing was rescheduled to June 12th of 2023 at 9 a.m. Looks like June 11th at 1:22 p.m. All parties appeared via WebEx. Counsel for the defendant, Ms. Lazaro, is fine with the defendant not being present for today's hearing. The matter is before the court on the defendant's motion to continue the currently scheduled detention hearing. And there was a detention hearing for the next day at 9 a.m. Looks like the detention hearing was scheduled for 6/12/2023. Happens a lot. That happens a lot. The motions here. Okay. Motion scheduled. Motion hearing on the 2nd. Memorandum in support of motion to appear in civilian clothing, which we just read. She wants to make sure everybody sees her looking good, looking fine, looking good. Appearance of counsel, notice of limited appearance. Filed a protective order on that day. Ruling entry, motion to appear in civilian clothing. Before the court is defendant's motion to allow defendant to appear without restraints and in civilian clothing throughout the trial. The state has not yet responded to the motion, and the state's deadline to do so has not yet passed. On a temporary basis until further order of the court, defendant's motion is granted in part and denied in part as follows. Defendant may appear at in-court proceedings in civilian clothing instead of prison uniform, and defendant shall be restrained as necessary to preserve the safety and security of defendant and the courtroom. The level and type of restraint shall be determined by the personnel of the Summit County Sheriff's Office. There you go. And everybody got that notice. Civilian clothing, 6/2/2023. Okay, keep on going down here. A hearing. This matter is before the court today. The motion for a gag order that has been filed by the state. Counsel for the state argues the motion for a gag order, and counsel for the defendant has a rebuttal to the motion for the gag order. The attorney addresses the court regarding the motion, and another attorney addresses the court regarding the motion for a gag order. Counsel for the defendant, Mr. Nate, rebuttal to the motion for gag order, and counsel for the state, Ms. Cassell, argues the motion for a gag order. The issue before the court is the state of Utah's motion for gag order. The court, for reasons stated on the record, rules that the motion is granted in part and denied in part as follows. Lawyers shall abide by 3.6 of URCP. The court is ordering the lawyers to inform members of their teams of this order, and they need to abide by it. The court orders that this order applies in all three cases before this court. The motion for gag order is denied in all other aspects without prejudice. The court will issue a protective order in this matter. Okay. Okay, so some of this stuff is just general stuff, and some of these motions and things like that, motion to clarify, motion to set conditions for release, all of those things, we'll go over those as well, because we have all of those and we can do that. All right, let's see. That was 2. Third, we went over the warrant already. The fourth is a report from Independent Forensics Labs. Let's see what that is about. Is this fun for anybody else, or is it just fun for me trying to figure these things out? I am intrigued at this point. This is intriguing. All right, let's get this opened up here. Let's present this one on this window here. Okay, this is in my paper. It's considered, I don't know what that is. The validity of the documents. Ooh. Independent Forensic Labs, June 8th of 2023. Let's make this a little bigger because it looks like it's not an original, it's a copy. So. Miss Margaret Olson, Summit County Attorney's Office. Dear Miss Olson, this report is in regards to a forensic document examination requested by Summit County. This is the initial forensic report regarding this matter. The documents listed below were received from Miss Kouri Richins Benson by attorneys at Bennett, Weller, Johnson, and Deere, and include writing in question, signed name and purported initials of Eric Eugene Richins found on the durable power of attorney, and the different parts of the terms of life insurance, the copies. So they were questioning, obviously, the validity of Eric's notarized documents, the power of attorney. Wow. I guess if she didn't know, I guess they would have to have it, validated. Writing of unknown authorship, Richins, Eric Eugene, 24 initials, and 86 signatures found on 186 pages. So they had just a ton of different things, different invoices, different tickets, gas tickets, sports stuff. It's different things that had his writing that was known. So this is the list of all of the signatures and the things that went along with it. All of his IRS things, verification and rehires for work, obviously, mortgage signature, new loan payment forms, occupancy and financials. So yeah, request for taxpayer, flood insurance. So all of his legal documents and anything that he had signed. That is a ton of stuff. Writing, so we got more. So they took a ton. You requested a forensic examination of the documents listed above to determine if 1. The 13 initials on Q1, the durable power of attorney, were genuine or forged. 2. The 13 initials on the durable power of attorney were genuine or forged. The 2 different pages, the 2 different documents. And then the signed name of Eric Eugene Richins on page 2, the true state individual term life insurance was genuine or forged. Okay, here they talk about the process of how they do it. Forensic handwriting examination procedures, which are used to determine the authenticity or lack of authenticity, actually involve 2 simultaneous evaluations. These are well-established handwriting examination procedures that have been documented and tested both empirically and experimentally for over 100 years. The guiding principles require that an examination must search for characteristics that indicate genuineness, as well as characteristics that may indicate forgery. Some examples that indicate genuineness are rapidly written characters, fine pressure gradations in strokes. Oh, conformity to the range of variation of the writer and several others. Some of the features that are found in non-genuine signatures are hesitation in the strokes, patching, retouching, and repairing of the strokes. Other potential indicators of forgery involve such things as tremor, constant or even pressure, letter forms that are outside of the range of variation of the individuals, and others. My conclusions, as stated in this report, are predicted upon my experience, training, and the evidence I found in the examination of the writings submitted, with no scientific evidence to contradict these findings. However, if some of the writings purported to be genuine writing is actually determined to be non-genuine, it may alter the opinion stated. These are his observations, or their observations. Initials and signatures of Mr. Eric Richins are used interchangeably as he authorizes and signs documents throughout the course of his daily activities. The initials on both Q1 and Q2 were all wet ink signatures. Page 9 and 10 on both Q1 and Q2 were photocopies and were copies of the same pages respectively. And the date 5/8/18 on page 9 of Q2 was altered and changed from its original date of 5/8/13, as shown on Q1, page 9. So he had an original document on 2013, and then 2018 he changed it. Professional opinion. There is no evidence that the 13 set initials on Q1 were authored by reread that. I don't think I was expecting the was I expected to say this strong probability that he did not write them. Wow. Okay, so did she forge his documents? Did she actually? Oh gosh. Okay, let me. June 8th of 2023, pages 5 of 7, professional opinion. 1. There is no evidence that the 13 set initials on Q1 were authored by Eric Eugene Richins. There is a strong probability that he did not write them. Was a different style uppercase E used in the question initials. Question's uppercase R is pictorial and mechanically formed different. 2. There is no evidence that the 13 sets initials on Q2 were authored by Eric Eugene Richins. There's a strong probability that he did not write them. 3. The signed name Eric Eugene Richins on page 2 of Q3 was probably not authored by Mr. Richins. Uppercase E's are connected in the question signature, but not in the known. The second E starts at the baseline, unlike the known E's, and the second E connects to the R, unlike any of the known signatures. So there's no evidence he signed Q3, and it appears to be a simulated forgery written by someone who is familiar with or has access to known signatures of Mr. Richins. If the original of Q3 can be located, it should be submitted for forensic testing. The forgeries in this case are simulated forgeries. This is when someone tries to copy, draw, or duplicate another person's characteristics and habits and tries to create a fraudulent signature or set of initials with enough similarities that I'm just dumbfounded right now. I'm sorry. With enough similarities that they might get passed off as genuine. The forger's characteristics are not usually within the forged writing, and the actual author cannot be identified because they give up their own habits and characteristics trying to duplicate someone else's. I hope the above information will be of value to you. Please let me know if I may be of further assistance or if you have any additional questions. That's insane. Insane. So this is the standard, the Scientific Working Group for Forensic Document Examination. So this is the standards that they go by to identify and wow. The evidence points rather strongly against the questioned and known writings having been written by the same individual, but in the probable range above, the evidence is not quite up to the virtually certain range. Probably did not. So they determined his was strong probability, did not. Not a complete elimination. So it's like the definite conclusion of identity. It's the highest degree of confidence expressed. So they were up here and strong probability did not. Is that what I remember saying? Not authorized. Probability. High probability was not. So yeah. So he was down here, strong probability that this carries the same weight as strong probability on the identification side of the scale. That is, the examiner is virtually certain that the questioned and known writings were not written by the same individual. Wow. That's crazy. This woman's got issues. I mean, obviously, we know that. Otherwise, she wouldn't be sitting there waiting. And then, it's been a couple of years. So the next one that we're going to go through the next time we come on looks like it's going to be 5. It'll be a prenuptial agreement, the crime scene body cam transcript, and the proposed gag orders. And then we're just going to go down, like I said, through the documents, and maybe we'll watch a few of the videos. We didn't really get to do that today, but they have the searches, the emails, the motions for bail, the briefings, the transcripts from her police interview. There's just so much to cover here. So I'm super excited. I'm so super excited. Yeah, so we've got a lot to learn about this case. We also will go to hold of the children's book that she went on TV. I know she went on TV and talked about the book that she wrote with her and her children about daddy's passing, about the father's passing. So as always, this is a part 1. I'm super excited for the rest of the parts. This Kouri Richins case is very exciting. Thank you to all of you who have been out there supporting me and waiting in the wings for something new to come out. Don't hesitate to leave a comment down below. Tell me if you're going to like this series. What do you think? And then the walk the dog letter, we're definitely going to read it. We're going to include it. So anyway, as always, thank you so much for hanging with Hio.